All right, y'all. Today, Karen Reed was back in court. Yannetti Little Jackson and Alessi, which that guy dropped some fucking mics today, man. Now, first off, I want to talk about Jackson. Look at the facial hair going on. And I really can't stand seeing Paul. So this was beautiful breakdown of today's events, kind of easier to flow. I had a whole thing written out, but I figured this is easier for people to digest. But we wanted to talk today about a bunch of different things. Voss's motion to exclude her reporter notes. So Gretchen Voss, she was a journalist for the Boston Magazine. She did an article about Karen, and she says that there was notes in there that were off the record. So Karen comes in, pre-trial hearing, and they argued over a bunch of different things. They wanted to see if we're ready for court April 1st, which we're hoping that this shit is shut down before then, because this shit is ridiculous. The more you listen and the more this defense attorney come forward with more shit to drop, why are we still here? Free fucking Karen Reed. Karen, free you. We're going to scream free you till we free you. So because of this, she's been getting some social media drama. You know, they want to put her phone number and kind of blast her. We all know how that goes. So they're trying to fight for the reporters' rights and saying that releasing these notes would affect her future ability to investigate and label her as a journalist to be not trusted. You know, these are personal notes that she promised when she was talking to Karen that they would not be added, they would not be discussed, just like a friendship or you're talking to a random person. Some things are off the record. It's just so the reporter can dig a little further, the journalist can get some more information. So Auntie Bev states that she's not looking for the impressions, but rather for specific info that is revealed by Reed. And she says that they will propose to redact notes to conceal her personal impressions before turning it over to the prosecutors. Now, Hanky Pank defers to the judge's decision. She's going to take it under advisement. I'll take it under advisement. But it sounds as though she's already made up her mind. We already know how Auntie Bev works at this point. But then we get up into the more critical stuff. The lawyers and judges discussing the prosecutor's attempts to get more information on the ARCA experts. This was huge. So they're arguing to ban the testimony of the defense's cell data expert, Richard Green. You remember, because that was the whole thing of 2:27 in the morning. What did you Google? When did you Google it? And getting that information. Now, this is a search done on Jen McCabe's phone about how long it takes to die in the cold. We all know that shit at the back of our hands. And Green testified at the first trial that the search happened at 2:27 in the morning, suggesting someone else, possibly unalive Mr. O'Keefe. He also stated he found evidence the user deleted info from the phone. Brandon says Green's analysis includes numerous misunderstandings and they're not factually sound. So they're trying to get it, removed. So Brandon says Green's conclusions were based on an artifact produced by the software of the company called Celebrate. Brandon says Celebrate has now updated that software so that it no longer produces what says as a false result. The prosecution said during the first trial that the hypothermia search was done after O'Keefe's body was found and at the request of Reed. Prosecutors produced two experts who said the search was done at about 6:30 a.m. This witness is comfortable to promote a claim that someone else killed O'Keefe. It has no factual basis, Brandon says. There was no deletion or manipulated by the witness or police, Brandon says, because he says if there were, there would be proof. So Brandon is asking for a pretrial hearing known as a Lanigan hearing, where Green would testify about how he came to his conclusions. He says that Mr. Green is just a vessel for the third-party culprit defense. He's stating that in his argument that he has got the science wrong. But then Alessi tells Judge Green that he is overly qualified to provide testimony on this case. Alessi says the prosecution did not raise any objection to Green's testimony at the first trial, and nor did the judge. The judge interjects to tell Alessi that objections are being raised now. Unless he disputes Brennan's claim that Green used no methodology, he describes the steps that Green took in reaching his conclusions. Unless he states suggestions of police manipulation are supported because he says the investigating trooper initially sent defense attorneys an incomplete copy of the cell phone data, which we already knew. Unless he states Green used 7 software tools to evaluate the phone more. So that's even way more than the prosecution came over there. Remember that lady? That lady was so crazy. I forgot her name now. It was so irrelevant. She was trying to like talk to people like they were 5-year-old children to explain how she knew. And I'm sorry, if you're searching on your phone, you're not deleting your browser and you're just going to Google and typing over there. You're not going to go back into the original browser that you used to redo that. I probably got 1,000 open tabs right now. Let's be for real. Now, Leslie says the issue in this case is not the methodologies used, but rather the opinions reached from those methodologies. He says differences of opinions do not require a pretrial hearing. So Alessi states that the prosecution's expert, Ian Whitman, has produced no explanation for why the artifact no longer appears in the Celebrate analysis. Alessi says it's the reliability of the prosecution's experts that should be called into question. Are you telling me we should have a hearing? The judge asked. Of course she's smiling, because you know how Auntie Bev is with her little smirky smirks, thinking this is a fucking game. But Alessi says that there's no need to have a hearing. And Alessi also states that there were 4,056 searches on McCabe's phone and only 1 deletion, the hypothermia search. He says it would be malpractice on the part of Green if he did not point that out. Alessi concludes his argument, and Brennan came back for a rebuttal, of course. So Brennan says it doesn't matter how many tools, says the search happened at 2:27. He states the timestamp when the browser was open, not when the search was conducted. That's the important part here. Well, we already established that one was a credible expert and the other 2, not so much. Brennan says he's willing to bring his own experts at pretrial hearing to evaluate Green's analysis. He says it would be unusual but proper in this case. And he concludes his rebuttal, and unless he comes back again. And so here goes the judge stating that it might be a difference in opinions, no need for hearing, but says she'll make a decision by Monday, so we will await. We already, like, at this point, any little thing is a win because, man, Auntie Bev, you be pissing us off. The judge asked Brennan to discuss how much evidence the prosecution has shared. He says he plans to complete that by next Wednesday. He says they have received the updated analysis of the data from Reed's vehicle. Now, Brennan says he personally gone through another phone in the case to evaluate if anything is relevant to the defense. Because, yeah, we believe he's going to do the right thing, right? The judge asked if the Commonwealth is going to be ready for April 1st for Karen's start of court date. They said yes. And Brandon says the only thing yet to be turned over is a neurologist report, a phone analysis, and an inconsequential witness review. Judge is now discussing the defense's motion to be reimbursed more than $12,000 for the expense of one of its experts who recently visited the Canton Police Department. Defense Alan Jackson says he will submit a supplement to that motion, and they're going to discuss that next week. And there's also going to be a hearing on February 18th to hear the defense's motion, because this is it coming. We're sneaking up here into the court date. We have to have somebody come in and drop this shit. Like, throw this out. Free Karen Reed. Let's stop with this bullshit. Judge says the jury commissioner has done a good job of getting a lot of potential jurors lined up for the April 1st start date, and that's it. So now we wait. Now, going forward, Karen Reed's defense team indicated it intends to file a motion to dismiss charges against her based on the misconduct. So we already know this. This has to be filed by February 11th, and then the hearing is set for February 18th. Now, the problem is they paid $12,000 for an expert to review the footage from the Canton police station. When the expert arrived at the station last month, no footage existed. Totally gone. And her defense is like, nah. We paid for him to come out. You're going to be paying the bill now because it's no longer there. That should still be readily available. And you can read below. What do you mean the footage is gone? Now, seriously, let's just end this bull crap here. This is like hanky-panky. Let's stop with the shit. You've seen this case. You know too. Karen is not guilty. Auntie Bev, for once in your life, do the right thing. Guys, what did you think about today? Let me know in the comments.